to Attorney Guo's New York Real Estate channel. Today we are going to discuss how to do power of attorney. We often say people say, I cannot go to the closing in person. Can I do a power of attorney in New York State? The answer is yes. New York State will allow people who cannot attend the closing in person to do a power of attorney. But we have to be careful about the requirement, what you have to do if you plan to do a power of attorney. First of all, we have to understand when you do power of attorney, there are two parties. First party is the principal. That's the person who want to authorize somebody else sign on behalf of this person. Second party is the agent. That's the person who is empowered, who is authorized to sign the document. Both parties, both the principal and the agent, has to be competent to do the legal actions. For example, somebody asked me, oh, I have a very old parent, my dad. So I want to do a power of attorney. If someday my dad passes away, so I can sign on behalf of him to sell the house. I think in this way, I'm sorry, you cannot do that. Why? Because when the dad is alive, the dad has the power, has the competence to sell the house. But once the dad passes away, then everything goes to the estate. So the dad does not personally have any power to sign because he's already in the heaven, and you cannot do such a power of attorney to do the legal transaction, to do the sale, to sign a document, because that does not have the power anymore. The same thing for the agent. You cannot say, I authorize my child who is maybe 15 years old, but so this child is a minor, so he has not competence to sign a document. Or is I authorize my parent who is very old, who is lying in a hospital, he may not be sober, so that's not also competent. So we have to make sure when you do power of attorney, both the principal and agent has to be fully competent to do the legal civil action. When you do the power of attorney, the signature requirement. If the person, the principal, is inside of USA, then you can go to any state. Like if you're in New York, you're in California, you're in Florida, you just bring the New York standard form of power of attorney we prepared for you. You go to a local notary public. The notary public will see you sign there, and they will witness, they will put a notary stamp on your power of attorney, so that will be done. But if the person, the principal, is outside of the USA, then you have to go to the US consulate in your local country. They all provide a service for notary public. So you bring your ID, you bring the power of attorney to go to the US consulate, and the officer, the notary public of that consulate, will notarize your signature. The reason why you have to go to US consulate is because according to international law, a US consulate is part of US territory. So you go to the US territory, which is inside of the consulate, then you get the notarized, you get the signature, okay? We have to also keep in mind, there are some special situation you cannot use power of attorney. For example, if it's an estate, then the estate already have the executor or administrator to sign on behalf of the estate. The law does not allow the executor or administrator to authorize another agent to sign. So you have to sign in person if you are the executor or you are the administrator. The same thing applies to trust. If it's a trust, usually the trustee is already empowered, authorized to sign document for the trust. So the trustee cannot say, oh, I'm not available, I just authorize an agent to sign on behalf of you. No, you cannot. The trustee, you have to sign in person. The third possibility might be it's a business corporation or it's a limited liability company. So usually those entities, they will have a shareholder resolution, the resolution will authorize one of the officers, like the president or secretary or treasurer of the corporation, to sign on behalf of the corporation at the closing. In that case, you don't need to do power of attorney either. The last thing, I just want to remind you, whether you are the seller or you are the buyer, if you do the power of attorney at the closing, as the seller, we always recommend you, since you already did a POA, power of attorney, your agent will sign on behalf of you. We really want to see at the closing table the proceeds all go to your name. We don't want to say, oh, agent shows up, you don't show up in person, and all the money goes to another person. That's a big signal, big alert for the title company to question whether it's a fraud. Okay, so if you try to make things smoothly, easy, we recommend just have the money payable to your name in person at the closing. Don't go to the third person anymore. If you are the buyer, you want to do a power of attorney. Also, two things you have to keep in mind. If you try to borrow a loan from the bank, we really recommend you have to double check with your lender to see their policy. Some small lenders, they are very, very careful. Their policy is the borrowers, they have to sign the closing document, loan document in person. So power of attorney is not allowed. If that's the case, then you cannot do the power of attorney. Or if you are the buyer at the time of closing, you don't come, yes, your agent can sign all the document for you, but you have to make sure to have a good arrangement how to cut all the bank's checks from your bank to pay the balance at the closing. If you are not there, who else can do your fund payment? Okay, so that's today's topic. And if you have any further question, any further discussion, you can feel free to contact us with the below contact information by emailing to me or calling me. Bye.